Hello everyone and welcome. Thank you for joining us wherever you're joining us from today for this panel event, Mandatory Human Rights Due Diligence Developments in Germany. My name is Anneloes Hoff. I am here in Heidelberg at the Max Planck Institute for Comparative Public Law and International Law, where I am a senior research fellow, and today I represent the Institute's Human Rights Discussion Group. We're delighted to have a fantastic panel of 4 experts on business and human rights in Germany with us today, whom I'll soon introduce to you. But first, I would like to make you aware that the first half of this session is being recorded and will be published on the YouTube channel of the Institute in due course. And you can find this YouTube channel under MPIL Heidelberg. There's also a link to it in the chat. Now, today's session, as you know, will focus on Germany's draft law, the Lieferkettengesetz, or supply chain law, which was approved by the German cabinet in March and introduced in the Bundestag, the German parliament, 2 weeks ago. And actually today it's being discussed by the Parliamentary Committee for Labor and Social Affairs. And most of you here will know the concept of human rights due diligence from the UN Guiding Principles, where it refers to this process by which companies can know and show their respect for human rights by identifying, preventing, mitigating, documenting, and reporting on how they address the human rights impacts of their activities and those of their business relations. And we may well say that mandatory human rights due diligence, which is this legislation which codifies the concept into a legal duty, is having a real moment, especially in Europe, where more and more countries are starting to develop this kind of legislation, including at the EU level. And the Lieferkettengesetz then is the German version of this law. And in today's session, our 4 experts will first talk you through the different elements and dimensions of the draft law, the political process surrounding it and its relationship to the EU developments. And after that, we will have over an hour to dedicate to your questions. And for this, we will be using the Q&A box, which you can find at the bottom of your screen. So please feel free to enter your questions there throughout the session. You also have the option to do so anonymously if that's your preference. And you can upvote other people's questions there. Now, without further ado, I will present our panel to you. The first speaker today, I will be presenting them in order of speaking, is Robert Grabosch, who is a lawyer with the law firm Schweizer Legal in Berlin. He specializes in commercial and corporate law and corporate social responsibility. And he has extensively commented on the supply chain law throughout the process, including supporting a rechtsgutachten or a legal expert opinion on the feasibility of drafting a supply chain law for the Initiative Lieferkettengesetz, which is the civil society network that forms the main driver behind this initiative. And secondly, we are delighted to have with us Frank Zach, who has been extensively involved in the process surrounding the development of the supply chain law, as well as head of the Eastern Europe and Asia Pacific division of the International and European Department of the German Trade Union Confederation. He's also a member of the Working Group on Business and Human Rights at the German Federal Ministry of Labor and Social Affairs. Our third speaker is Professor Eva-Maria Kieninger from the University of Würzburg, where she holds the chair for German and European private law, as well as private international law. She has published extensively on private international law and German law of obligations. And she has also commented on the supply chain law initiative in the run-up to the release of the draft, in which she emphasized the importance of giving this law teeth for it to be able to be an effective instrument, on which we will certainly hear more today. And last but certainly not least, we are very happy to be joined by Dr. Miriam Saage-Maaß, who is the Vice Legal Director of the European Center for Constitutional and Human Rights in Berlin, where she has built up the Business and Human Rights Program. She is an expert on corporate accountability and supply chains, on which she has not only extensively published, but which is also an issue she has been closely involved with as a practitioner, working on various cases of worker exploitation, the most well-known of which is probably the case against German retailer Kick concerning a textile factory fire in Pakistan. And she's been deeply involved in the process surrounding the supply chain law as part of the Initiative Lieferkettengesetz, providing expert input at various stages, though today we will hear to what extent she considers any of this may be found back in the current drafts. So with that, I would now like to give the floor to our first speaker, Robert Grabosch.
Thank you so much, Anneloes. I am honored to introduce to you the personal scope and the material scope of this bill, as well as the content of the duty of diligence. This bill is getting many things right, and it may indeed become one of the most effective human rights due diligence statutes worldwide. So this act will apply to certain German companies as well as foreign companies with their administrative seat or their principal place of business in Germany. And it will apply to companies that employ at least 1,000 workers in Germany or abroad. The workers in subsidiaries count as well, and apparently part-time workers and apprentices will count full-time also. Now, what I find a bit dissatisfying, I must say, about the bill is that foreign companies largely fall out of scope unless they have their principal place of business in Germany. And it would really help German companies if their foreign suppliers, as well as foreign competitors, were also obliged to apply diligence by law, especially if those foreign companies operate business sites in Germany, like warehouses or stores. On the bright side, however, this bill achieves something remarkable when it comes to the confusion of what human rights should actually mean to companies. For more than half a century, people have struggled to make sense of human rights in business environments. Many concerns have been raised. Do human rights exist at all? Are they really universal? Aren't they mere aspirations, political declarations of intent? Don't they bind only states? And aren't they too vague, too abstract to be applied in law? And corporate law, after all, requires managers to ensure compliance with law only within their company and to not waste company money on nice-to-have CSR. And all these concerns are valid to a large extent, but many of you who have followed the debate for a long time will be quite aware of a certain frustration because some business representatives are exaggerating these concerns in order to obfuscate the debate and escape the burden of responsibility rather than engaging in constructive exchange. So very often have we heard that human rights just don't make sense in the business context. So now this bill ends this discussion in a unique and surprisingly simple and helpful way. It translates human rights to some very specific definitions of risks, 11 + 1 + 2 risks, which are explained in detail on 3 pages of the statute. So next slide, there is the list of these risks. And you see here only a short title, but again, on 3 pages, the statute defines these risks very specifically. 11 risks to human rights, a 12th risk as a fallback clause, and 2 environmental risks. And I'm not saying that this approach is perfect. Some of the risks are not super specific. They will need to be discussed in detail. For instance, risk number 7. It isn't obvious if a minimum wage is too low and how much higher exactly the living wage would be. But let's be realistic. This act will be enforced by 65 state officers who are supervising 2,900 companies. And their focus will not be on tedious issues, but really on the biggest risks. There's also a controversy about the catch-all risk definition in number 12. But read number 12 carefully and you will see how high it sets the bar. These are risks that companies really should be aware of already. And for further reference and clarification, these risks definitions refer to 13 conventions. And these conventions are on average 56 years old. So there really isn't very much new that is expected of companies, except that finally these conventions are being enforced. And if as a community, states want to achieve the Sustainable Development Goals by 2030, there really is a need for statutes like this one. Child labor, you see here listed as risks number 1 and 2, must be eradicated by 2025, and this is in 4 years. Regarding the reach of diligence, the companies will have to apply diligence in their own business area and that of their direct suppliers with whom they engage in a contract. Now, this bill does not consider company groups. If a subsidiary does not supply the company, but does its own business on its own, the company will not have to direct diligence at the subsidiary's business. However, parent companies often exercise control and manage the subsidiary's business very tightly. And in these cases, I would argue that the subsidiary's business area is also the parent company's own business area. Section 5 of the bill has been heavily criticized by NGOs for that. Section 5 seems to limit the reach of diligence at tier number 1. A more expansive reading of Section 5, paragraph 1 would be possible, meaning that a company would have to carry out diligence in its own business area, and in doing so, consider the entire chain. But the arguments are in favor of a narrower interpretation. The reach of the regular diligence will end at tier 1. But make no mistake, there are 2 very strong ad hoc duties of diligence. When a company introduces new products or projects or enters new business fields, and when it obtains substantiated knowledge of a possible infringement, it must perform a risk analysis and apply mitigative measures anywhere in the chain. So this act will get stronger over time. So what measures are companies expected to take? First of all, the government's justification for the bill makes it clear that every duty under this act is an obligation of effort, not of result. Companies are expected to make appropriate effort, and if damage happens anyways, they won't be liable. The appropriateness is defined by 4 criteria in Section 3, namely the ability of a company to influence a violation, the typical severity, reversibility, and probability of the violation, and the nature of the causal contribution, as well as the nature of the business activity itself. Companies must introduce a risk management concerning the risks defined. They must assign responsibility to designated staff members and apply appropriate measures to identify and mitigate risks. And that means that risks must also be analyzed and prioritized and communicated to internal decision makers. A policy statement must be made. Several preventive measures must be taken out in their own business area as well as that of their direct suppliers. And these measures are also identified in the wording of the statute. Remedial action must be taken, and the companies must prepare documentations and frequent reporting. The bill also makes it clear that withdrawal from a business relationship is only the ultima ratio. At first, companies must try to mitigate risks, and only where a violation is very severe and the concept of mitigation does not appear to work, no other measures are available, and an increase of leverage is not likely. Only in these cases, a company must withdraw from a business relationship. So overall, this is a strong human rights due diligence statute by comparison with other countries' similar statutes. And there will be, it's not a perfect law. It's too weak for the criticism from the NGO side, and it's expecting too much from the companies if you ask company representatives. But there will be 2 evaluation mechanisms over the next 5 years. And I strongly believe that this is a very good first step, and improvement is possible. And this bill should really enter into force. And that's it from my side for now. So back to Anneloes and to Miriam next, I believe.
Wonderful. Thank you very much, Robert. we already see some questions coming in as well, which the panelists are also answering in writing when these are very concrete questions. So you will be able to find further elaboration in the Q&A box. And I'm glad to see that Eva-Maria Kieninger has also found her way back into the session. So with that, we can continue with the next speaker, which is Frank Zach, please.
Yeah, thank you for the invitation and to get the possibility to talk about this. I think, yes, new draft law, what's now discussed in the German parliament, and we are looking forward what will happen in the next 2 or 3 weeks in this parliament. But let's start a little bit with the positive aspects of this draft law. And I think it's with this draft law, human rights and also working conditions along value chains, global value chains, can be strengthened and improved. This is, out of my view, a very important step toward to fair globalization. And that's this gives really a chance to take human rights and basic labor rights out of the partly merciless competition for the cheapest production conditions. And Robert mentioned it already, the law specifies all essential human rights, in particularly the human rights that affects workers, especially the terrible catastrophes in the textile factories, but also violations of trade union rights. The lousy wages and unsustainable working conditions are the reason for this legislative initiative. The draft law provides the basis for finally integrating human rights into corporate risk management. I think that is also an important step. Not the risk for the companies, it's more the risk for the people who are working in the global value chains. And I would say this law is far from being a toothless law. Its strength lies in a clear regulatory control and enforcement. This is something new, that the action or omission of companies across the borders of Germany are checked from a public authority. But one thing is clear, and Robert mentioned it already, this draft is more a compromise. And I would say it's a fragile compromise between different political opinions inside this government. Nevertheless, I see scope for maybe at least minimal invasive changes in the law, but and Robert mentioned something where we see some failures and mistakes inside this draft. The requirement, for example, of business associations to include companies from abroad which do good business here in Germany in the law makes perfect sense out of my view. A concession to the business side at this point opens, I think, room for improvement in workers' interests, or maybe also in some opinions of the non-governmental organizations. The next point is, in our country, we have a long culture of co-determination in which workers' representatives are involved in management processes. My question is, why not also in the Supply Chain Act? Many of our works councils and supervisory boards can contribute with their expertise in the risk management for human rights. We have also some small illogical mistakes, and I will mention some. Unfortunately, when determining applicable human rights, often this draft reference to national law, for example, by the freedom of association, occupational health and safety, and also by fair wages. it is, but you have to see that often the lack of application of national law makes it impossible for people to form trade unions or to get fair wages or to have safe workplaces. Overall, as far as possible, the entire value chain should at least be included in the risk analysis. And Robert mentioned it, it's absolutely right. For example, child labor mostly takes place in the extraction and raw material sector of global supply chains. For example, cacao plantations or in the mining sector. And that is not tier 1, it's mostly tier N in the end of the global value chain. Maybe short, what we are missing. I think the most part, what we are missing is that the draft does not contain a civil liability under German law. This is probably not feasible with the Christian Democratic Union so far, we understand. But the offer to trade unions and non-governmental organizations to lead a process for victims of human rights violations maybe is charming, but it's only a compromise and one foot in the door to get more civil liability in the sector. However, I think what has to be mentioned is that it is important to define this due diligence law as a protective law and not a law for public interest. We see now some debates inside the parliament that especially the people who don't want to have a strong law tries to put out the protective part of this law and look more for the public interest. To make it clear, if courts are tried or involved, something has already happened. However, it is better to act preventively, even from official channels. That is why I think it's just as important that trade unions and NGOs can report neglect of due diligence to the new authority in order to prevent possible human rights violations. It is also important that the debate in the Bundestag sent a clear signal to Europe in favor of a strong EU regulation. With this, the next federal government can make improvement where, from your point of view, there is some deficits. But have a look a little bit on the history of this law. In Germany, we had a lively debate about the implementation of the UN guiding principles on business and human rights. And it starts years ago, I think 2014, when it was the intention of the federal government to present a national action plan. During this debate, trade unions and civil society organizations made it very clear that statutory regulations would be the best way forward. The federal government could not bring itself to this. However, the government formulated clear expectations to companies in terms of due diligence. Compliance with these expectations should be checked through surveys of companies. And the results of these surveys was that only 70% of the companies fulfilled their duties of care. That was the reason to take legislative action. This was strongly accompanied by extensive activities by an alliance of around about 120 organizations that came together to form the so-called Supply Chain Act Initiative, Lieferkettengesetz. The initiative is supported by trade unions, organizations from the church, human rights protection organizations, development organizations, and environmental protection organizations. I think so far I know one of the biggest alliance for one political issue in Germany in the last decades in Germany. At the end, that 3 ministers were commissioned to draft a law out of the expectations of the federal government. There were the Minister of Labor, the Minister of Development and Economical Cooperation, and the Minister of Economic Affairs. The Labor Minister and the Development Minister wanted to have a strong law, and they mentioned it very early, 2 years ago. The Economy Minister wanted to have, in the best way, no law. And that means, or in this period, or at this time, the initiative and its organizations put a lot of political pressure on this process. I think many media reported about the lack of due diligence inside of companies. They reported about violations of human rights and so on. And it was also about the implementing the requirements of the government program by the end of the legislative period that brings these 3 ministers together on one table and at the end to reach a conclusion. This debate was between the 3 ministers lasted for a long time, and it was in some places connected with considerable internal disputes. And so far we know in the end, the Chancellor probably also had a word of power to come to a conclusion. In fact, the result is in compromise. And I would even say a fragile one, leaving little scope for major changes. And now, you mentioned it already, the Parliament deliberations are now picking up speed. Today, the draft law was introduced in the Committee of Labor and Social Affairs. According to the known planning, there will be a hearing in this committee, Committee for Labor and Social Affairs on May 17th. 2 days later, the committee then finally discuss about and comes to recommendations to the Parliament, to the Bundestag. And the Bundestag then has the second and the third readings of this draft law, and following, I think, also a vote about this law, and comes then to a decision on May 21st. As next, the Federal Council will be consulted. However, so far there is no evidence that the Federal Council will have any objections up to now. But you know, nobody knows what can happen in the next weeks. Therefore, I think very interesting times for us as trade unions, for the civil society and the civil society organizations. And every morning, the first step is to look what has happened in the Parliament and the internal debates between the coalition parties. And I'm also very looking forward to tonight. There will be a meeting of the faction of the SPD, and they will meet not only the labor minister, they will also meet my president from the German Trade Union Confederation, and I think he will promote a little bit the good idea of a strong law for due diligence in Germany. So far.
Wonderful, thank you very much, Frank. So as you already mentioned, there is some scope for amendment, and one issue that you raised was the issue of non-German companies that do business in Germany potentially being included, and there have been some questions regarding this, so perhaps you could address this immediately. So Rachel Wittes, for instance, is asking, in terms of a level playing field, it is perhaps surprising that the proposed law will not cover non-German companies. Also, it is anticipated that the EU Sustainable Governance Initiative, so the EU Mandatory Human Rights Initiative, will cover companies not established in the EU for product, services, activities in EU member states when transposed. So in that case, Germany would still fall under this kind of arrangement. And someone else is also asking, would it be bureaucratically and judicially easy to allow to also include foreign companies in the German law. So Frank, could you maybe respond to these?
I think the better is Robert who can answer it, but I can also do it. It's possible to cover this companies who have business in Germany. And not only, but Germany would be the first country, I think so far I know, the Netherlands parliament with their child labor law also included all companies who do business in the Netherlands. And therefore it's quite, I don't know why they put out the companies coming from abroad. So far I have heard the first idea to put some civil, the liability under the German civil law could be one reason to exclude companies from abroad. Because if you want to go to the court, then you have to have you have to be in Germany and not from abroad. But after the ministers and also the parliament will decide against liability under German law, I think there is no need to exclude these companies. And I think the demand of the business associations to put them in the law, I think they have a lot of people who are, well, they know very good about the German law, and I think they have some good ideas to include this. But nevertheless, I think so far I know Robert has also some good ideas to include this, because it's quite easy. You can put it in the law that everybody who is doing business here in Germany and has to pay taxes, by the way, can also be included in this law.
So what would your more legal take on this be, Robert?
Right, it is certainly possible, and as Frank said, the Dutch Parliament has done it with the Dutch Act on due diligence against child labor. That act applies to German companies if they deliver goods twice a year to the Netherlands. Such an act that applies to foreign companies raises a bit of concerns with the European basic freedoms, but as far as I understand, such an act would still be justified. And it is possible to enforce it. Of course, the Federal Office for Export Control will not be able to send their own officers abroad into the company premises and search company premises and interrogate people. That would violate other countries' sovereignty. But they can ask questions by letters which will be delivered by diplomatic aid, and they can issue fines. And when a foreign company has a bank account in Germany, or has a warehouse in Germany, or operates a store in Germany, the property of the foreign company can be attached, as well as claims for the payment of supplies delivered. These claims against German companies can be attached and seized. So such a fine could well be enforced. And remember, the United States are doing just that. Whenever Russia buys a pipeline somewhere, they issue embargoes against all companies anywhere in the world, even when they are not doing any business in the United States. And they apply their fines and their sanctions years later, whenever a company official sets foot on the United States premises. So such an act would really not be unusual.
I saw Miriam also raised her hand. No? Okay, well, Eva-Maria did, so please, Eva.
Yes, thank you very much. Just a few sentences on this issue from the point of view of civil liability and also private international law and international civil procedure. I would even say that it is a civil liability which is more easily enforceable towards a foreign company than administrative sanctions or penal sanctions, because it's not true that you can only sue German companies in front of German courts. So as far as the Brussels I regulation is applicable, which is applicable to all companies incorporated or having the principal place of business within Europe, then the Brussels I regulation applies. And it's not only the corporate domicile where you can sue a company, you can also sue it at the place where the harmful event occurred. And if you take due diligence, human rights due diligence violations, the harmful event is the act of the company, the omission of the company. It's not where the subsidiary is, but if you define in a global in a supply chain act, if you set up due diligence obligations, it's the omission. So it's a company's headquarters. So all I'm saying is, as a result, as long as the company's headquarters are within the EU, you have no problem suing that company in Germany if the harmful event occurred in Germany, or you can sue it in front of another member state's court. Now, when the company is situated, has its principal place of business outside Germany, or outside the EU rather, the Brussels I regulation doesn't apply. It's autonomous civil procedure law, German procedure law, which applies. And there you can sue a company which has its headquarters abroad if the company has patrimony in the territory of Germany. So that's another possibility. And also under autonomous law, you can sue a company where the harmful event occurred, so the harmful act. So you can sue those companies here. I think that the higher problem, or the more important problem, is what Grabosch said. It's the fundamental freedoms of the EU treaty. I think that's a bigger problem. But of course, maybe justified. Restrictions may be justified.
Okay, well, I think that's a great intro to your contribution already, which focuses on enforcement. So yeah, please continue.
Well, thank you very much. I prepared a presentation, and I will now try to share this with you. So, just a sec. So, can you now see it? Fine. Okay.
Yes.
So, I will put a little bit water in the wine that has been prepared, especially from Mr. Saage. And I will talk about enforcement of this Future Supply Chain Act. And I would say that ideally, we should have three pillars of enforcement. We should have administrative control, criminal sanctions, and civil liability. Presently, this German Supply Chain Act only has two pillars, and two of them, as this picture shows, are also quite defective or broken. What we have is in section 4 of the draft law and paragraphs 12 and the following, administrative control and enforcement. And the companies who infringe the due diligence requirements can be excluded from public procurement. That's a powerful sanction, I think. And then we have under section 6, penalties and fines. So why am I saying that these pillars are not as good as they could be? Let's first have a look at the sum of the fines. And when you look at those very lengthy paragraphs in some more detail, you find that generally speaking, the fine is from 100,000 euros to a maximum of 800,000 euros. Now, I'm not saying that this is not money. Of course it is, but when you look at the size of the companies that are presently within the realm of application of this act, it might be not so much, and it might be worthwhile infringing these due diligence requirements and still and maybe running the risk of a fine and still gaining something. The only occasion where you have a considerable fine, which would probably hurt a company financially, that's for companies with more than 400 million euros annual turnover. And there the fine can amount to up to 2% of that turnover. But when you look at it closely, this fine can only be stated under paragraph for violations under paragraph 7, section 1 and 2, and those are violations of the duty to remedy human rights violations that the company has taken notice of through its own risk analysis. So my first question is, what happens if the company fails to analyze its risks in the first place? So can it still run into a violation of paragraph 7, or isn't it a clever way out of this very high fine of 2% of the annual turnover to just not analyze the risk at all? And remember, we are here in the realm of criminal law, where there must be a strict penalty. There must be a strict interpretation, no analogous application, and so on. And another feature of this paragraph is that it only relates to the company's own businesses and its direct tier 1 suppliers, this paragraph 7, section 1 and 2. And I think that is a very severe limitation of this fine. And outside the realm of this paragraph 7, section 1 and 2, you have just the maximum amount of 800,000 euros. And I would say that's not a lot. So turning towards the administrative control, who is going to administer this law? And I've taken this picture from the web page of the Federal Office for Economic Affairs. You see the pencil, you see the post-its. I think that's telling enough. Quite clearly, at present, and I mean the Act talks about hiring 65 experts for this agency in order to enforce this law. But presently, if you look at this agency, you can doubt whether it's really up to the task. Because when you look, for example, at what they do in the textile sector, they issue certificates for the importation from the Republic of North Korea. That's all they are doing presently in the realm of the textile industry. So the question is, why on earth did they choose this body? One reason may be this person, the Ministry of Economic Affairs, because this agency is under his control and the control of his ministry, and that's exactly what the Act says, that this agency, the administration which is going to control these human rights due diligence obligations, will be under the surveillance of the Economic Ministry, not under the surveillance of the Federal Ministry for Economic Cooperation and Development, which was the driving force behind the Supply Chain Act. So that's another drawback in my view. So then we come to the third pillar, which is non-existent, and that's private enforcement. We have already said that there is no civil liability provision in this Act. The only thing we have section 3, which is headed by civil procedure, and there's just one paragraph which says, as you can see here from my translation, any person whose rights under section 2, subsection 1 have been violated may authorize a domestic trade union or non-governmental organization to take legal action to enforce his rights. And that's under civil procedure. So it's not within an administrative procedure that the NGOs and the trade unions are empowered to take the parts of victims. It's under civil procedure. So the question is, what civil procedure should there be? So that's the big question. Well, in my view, the draft Act simply stays silent on the whole issue of civil liability, says nothing on private international law. So it leaves everything open and leaves everything to court practice. And the big question, once this Act will have been passed, is do these obligations, which are stated there for companies, do they amount to what's called a Verkehrspflicht within the meaning of 823 subsection 1 of the Civil Code? or even to, do they amount to what's called a Schutzgesetz, a protective norm under Section 2 of the same norm. And if you look at the jurisprudence of the highest court, civil court in Germany, the ECCHR, then in my view, it's very likely that the courts will classify these obligations as being protective norms under Section 2 of 823. But of course, I mean, nobody can really tell with any certainty what's going to happen in front of the courts. One problem the courts will face when they want to give force to these obligations under German tort law is that if they qualify it as a protective norm, even economic loss would be recoverable under German tort law because it's Section 2, and there would be no limitations. So, I mean, perhaps there's a certain floodgate argument here that might prevent courts to go down that road. Nobody knows. I mean, what this act, with respect to tort law, what this act does is it creates uncertainty for all sides. That's my main criticism, really. Another important point is the burden of proof. Because under German law, there's an all or nothing principle. We don't have, like the French have, the perte de chance theory, so where you even, where liability can even be incurred for the loss of a chance. We don't have that. We have an all or nothing principle. So either the victim is able to prove that his loss or her loss was caused by the human rights due diligence violation, or if it cannot prove that as a conditio sine qua non, so a but for test, if that proof is not possible, then the victim will lose its case, or his or her case. And that makes it, in my view, very difficult for victims and very easy for companies, because what they will regularly do is that they will say, but even if I had acted 100% according to this Human Rights Due Diligence Act, still the subsidiary in the Global South would have just acted as it did, and it's not my fault, and there's no causal link. So finally, or close to finally, the last point here is which law is applicable. Again, the Supply Chain Act says nothing on private international law, so it leaves us with the Rome II regulation with Article 4, which says that it's applicable to the law of the state where the damage occurred, and that will be the place where the victim suffers damage to his or her health, life, freedom, and so on and so forth. And for the typical cases, then German law would not be applicable. So this beautiful Supply Chain Act just doesn't apply. The only possibility to make it applicable is through Article 16, through a qualification as an internationally mandatory provision. According to the jurisprudence of the European Court of Justice, that's a possibility. It's up to the member states to qualify their laws as internationally mandatory. And if they don't do it explicitly in the enactment, like with the Supply Chain Act, it's again up to the courts. So another possible source for liability, but also another source for legal uncertainty. So of course, this could be done better. And that's my last slide. I would not advocate for an overall liability of German companies for everything. What I would do, if I were the legislator, I would say that certain specific absolute rights which are also protected under German tort law in 823 section 1 should be protected here as well. That's foremost life, health, freedom, property. And I would even go one step further and say, because the Supply Chain Act has a very, I think, a well-drafted paragraph 2, where it sets out specific gross human rights risks. And if a company has violated or infringed those human rights, I mean, that's child labor, that's slavery, restrictions of freedom of association, discrimination, dangerous working conditions, all that. If that's at stake, and this has led to an infringement of life, health, freedom, and property, and I think then there should be a presumption that the damage was caused by the lack of human rights due diligence, and there should be a reversal of burden of proof. And all that should, of course, be named an international mandatory provision. And then we have a functioning third pillar. Thank you very much.
Thank you very much for also perhaps dampening the mood a little bit, but for good reasons, I think. So a lot of questions have already come in, but first I would like to give the floor to Miriam Saage-Maaß, and then after that we will get to all of the questions on applicable laws and what would happen in certain cases of lawsuits. So please, Miriam.
Thank you, yes. So I think I want to start my input with some more theoretical remarks, which I find highly relevant for the legal practice nevertheless. And that is basically, I think, also what this debate about the law comes down to, is the question, how does law change social realities, right? And to some extent, on this question, whole libraries have been written on. You know, how can a law ever affect reality and change something substantially? No? And that, I think, and that question is becomes even bigger if you think about the challenges of human rights abuses in global supply chains. And so obviously, I think the legitimate question is, well, how can one law ever achieve anything? You know, not so much about like, you know, just to be a bit realistic, you know, we want this law to be changing everything, but, you know, realistically is how can a law ever change anything? And I'm saying that actually from the legal practitioner's perspective. So, and I think already that it's clear no matter how perfect a law is written and drafted, it will all come down on how it is going to be implemented. And I think Eva-Maria Kieninger pretty well showed, obviously, implementation is happening on 3 pillars. It's administrative, it's criminal, and it's civil private enforcement. I think another layer that needs to be put there, who are the actors that are going to enforce such a law? And obviously that's the administration, government agencies, it's the criminal justice system, it's courts, but then also very importantly, it's the companies themselves, because they are in the first place supposed to, you know, implement this law. And then obviously it will be unions and civil society organizations. And so when we look at this law and think about how effective will it be, we actually also need to think about which role will all those 5 actors that I've named be playing in implementing this, no? So just a little bit to also, I know we're all lawyers and I see all the questions, and lawyers love the details of legal provisions, I sometimes feel like, well, but, you know, in the end, what I can also say that even a flawed law can be implemented quite effectively if the enforcement agencies and courts have the political will to do so. You know, so, and that means that comes, and obviously Eva-Maria Kieninger again has pointed out, so, you know, will the government agency of the BAFA be the right place of enforcement, and will there be political will? I think that's reasonably to be questioned. Unfortunately, I also have to say, do we really believe German civil courts will love to have cases brought by Bangladeshis or Pakistani workers on violations that happened in Pakistan? I have the experience that the presiding judge of the Landgericht Dortmund was less than happy about such a case. So, and additionally, we cannot count on courts having much expertise in dealing with those cases. So that means Then we come to the interpretation of laws. And I think also there we cannot be naive, because I think the interpretation of the law, for example, what it means to have an appropriate what is an appropriate human rights assessment, risk assessment? What is angemessene Maßnahme zur Erfüllung der Sorgfaltspflicht? All of those terms will have to be interpreted and implemented. And obviously, every time we interpret norms, this is a struggle. And it's a struggle between different opinions. And obviously, there will be the struggle between those actors that are on the side of businesses. And I don't trust courts enough to believe that they're automatically on the side of workers. If we put this now, business workers, obviously, the side of affected people is much wider. But obviously, this will, the moment this law comes into question, I think the real battle actually starts about interpreting, about negotiating on what this means and how it's going to be implemented. So now then this, as to start with. Another thing I have to say is that this law absolutely is a game changer, despite all flaws that have been outlined, simply because it is a complete, clear turn away from voluntary CSR standards into binding regulation. And I think, with all the nitty-gritties, what's, can render this law quite ineffective, it's still a major change. And I think, and I from my practitioner's perspective, I cannot overemphasize this, because normally we've been running around, showing codes of conduct and saying, oh, by the way, have you ever heard there's an international standard? Companies should be applying that. And the company usually says like, oh, well, thank you, but no, thank you. It's not binding to me. With this law, they simply cannot generally, like this basic, like pushing away any human rights claim is not possible anymore. Will it be enforced effectively? Well, that remains to be seen. I think what is clear and what is problematic about the law, it does not turn the preventive approach of the UN guiding principles into law. It clearly neglects the preventative approach, which means that actually companies should be taking due care to even prevent any human rights risks. This law much more obliges companies to actually look at actual risks or at risks that have already realized. But I think also, again, here, the law does give a role to negatively affected persons. And again, this may seem, quite negligible. Well, it cannot be neglected, because what the position currently victims of human rights abuse are in is they somehow wander around the scene, write an email to a CEO or to a company that says, who are you? I don't know. Or they may issue, if they have an NGO or a union on their side, they may issue a report, and someone, we are publishing our reports, making fuss about human rights abuses. And if we're lucky, someone picks this up. And if we're unlucky, no one picks this up. What you have here, if you can actually claim, here's a violation has happened. There are two. The company must be looking at this. Companies must be installing a complaint mechanism, where affected persons can bring their claim, which then immediately means that the company, and that's also for affected persons further down the supply chain, the company will have to react on this. At the moment, I can't tell you how often I've been writing letters to companies and they didn't even respond. And then afterwards, they were very surprised why they got either a criminal complaint or an OCD complaint. Well, this won't be possible anymore under this law. Additionally, what negatively affected persons can do, and again, they have to be already affected, so you can say it's too late. But again, it's more than what they can do now. There's a clear procedure that victims can pursue. And this procedure means they file their case or their grievance with the German authority and say, by the way, I think this company really neglected their human rights due diligence obligation under this law. You must be doing something about this. If the government agency doesn't do that, those individual victims can take the government agency to court. It's a normal administrative court route that can be then taken. Now, again, yes, that's it's not immediate remediation, it's not immediate damages. And yes, it's sort of an indirect way of pushing the company to go somewhere. But again, my daily business is to think creatively about avenues of, of redress, and they don't exist under German law. You can think of crazy, maybe file a criminal complaint here, maybe, ineffective OECD complaints, and if you really try hard, you can also go to civil courts. But here is now a foreseeable procedure, and despite all them, we can talk more about the weaknesses of this. It is more than we have now. I think one remark as to the fines. Yes, of course, fines are too low, and if you compare it with other areas of law, they could be much higher. I know people that are advising large companies in compliance issues, and those compliance lawyers all said, but anyways, the fines and the potential of even getting a fine that goes 2%, that takes 2% of your revenue, is a complete game changer in the sense of where this is going to be located in the priorities of companies. Because through those fines, you do get quite closely that, and also actually in the law itself, it's negotiated. This becomes a director's duty to have a look whether the company has appropriate human rights due diligence mechanisms in place. Again, this doesn't mean that real change will ever happen on the ground, but it means, again, also a game changer for companies on how serious they have to take human rights issues. On civil enforcement, yes. I mean, I think this law is, as Maria Kieninger said, more or less not useless. I mean, useless for civil enforcement. But again, I mean, we are still left with the possibilities that there are, and I think all that can be said is that with the most recent decisions in the UK courts that are pretty clearly establishing parent liability for human rights abuse and subsidiaries, and that especially established that company guidelines, both internal but also external code of conduct, are a way of establishing that the company is taking over responsibility for its subsidiaries, which then create liability. I think this jurisprudence is important as it does potentially apply to all former British colonies in the end, because they all tend to be common law systems. And therefore, I think also companies can rest assured that there are a number of civil law lawyers that are thinking of ways of still making use of this jurisprudence also in continental Europe. And we've seen also some successes in the Netherlands. So I don't think, while I guess I agree with Maria Kieninger, the Bundestag is sort of leaving the situation in complete unclarity, which, I feel, yes, it's probably a pity. At the same time, I'm also a bit torn because, applying common law on civil cases can, I think, in many ways be much more advantageous than applying German Delictsrecht. I think, yes, there's a clear pillar missing, but again, I think we are definitely better off with what we have than less. So probably one last comment that I wanted to say about enforcement, and I think one thing that I think also lawyers tend to forget is the law is making the suggestion, I think it's in paragraph 7, where it says that a way to fulfill your human rights due diligence or a way to find preventive actions is to engage in something like multi-stakeholder initiatives. And I think what needs to be the struggle for trade unions, but also for civil society, is that we make it a standard that companies must be engaging in enforceable brand agreements like the Bangladesh Accord. And I think if it meant that exercising your human rights due diligence in the sense of this law is the best way you can do is to engage in enforceable brand agreements and similar initiatives that are legally binding, I think that is what's going to bring the real change. And I think, therefore, I think sort of like the whole struggle that will come once this law is enacted needs to be that there must be robust mechanisms that companies enter, because which give more weight and more voice to workers and affected persons. And I think that is, how can I say, this is difficult to regulate in a law. So this is why I'm so much emphasizing this will be a lot about how is it implemented. And that does not only, is not, how can I say, it will require all the creativity that there is from the side of academics, lawyers, and unions and civil society. Thank you.
Great, thank you very much, Miriam. So the floor is open for questions, and there's already a lot of them coming in. Just a reminder that you also have the option of liking a question with the thumbs up button and thereby upvoting it. So I see Eva-Maria has her hand raised to respond to Miriam, I assume. So please go ahead.
Yeah, very shortly, of course. Thanks very much for bringing up the English jurisprudence on human rights due diligence and tortious liability. It's a very strange coincidence that on the very day that the three ministers presented the Supply Chain Act, the UK Supreme Court handed down its Okpabi judgment on this Nigerian law. Now, coming back to the question or the issue that you raised about the private international law, of course, I'm not saying, or I'm not part of the group of people who are saying that German law is in any event the best law and the best protective law. I think quite to the contrary. But what the current draft German Supply Chain Act does in effect is that it, it's all uncertain, but if German courts would shield the companies which come under the Act from tortious liability, then the small and medium-sized enterprises are worse off in terms of liability than those companies which have 1,000 or more than 3,000 workers, because the smaller and medium-sized companies would still be affected by the, in my view, much stricter tortious liability which is developed by the English courts, and they could not invoke the German Act as an internationally mandatory provision. I mean, that shows once again, I mean, I absolutely understand the enthusiasm for this act, and that for the first time these cases are taken notice of, that there is a German Act on it. But I think one cannot close one's eyes towards the obvious defects of this piece of legislation, at least not, well, I can't.
Thank you. Very fascinating also here to see kind of a tension between the legal academic and the legal practitioner, perhaps, in how you read this kind of a law. Frank, please.
Yes, maybe to add a little bit, practitioner, legal practitioner and legal academics, and maybe political practitioner. It's nice to talk about deficits of a legal draft. And I think it's absolutely correct to talk about. And a lot of deficits you mentioned are absolutely right. But then you have to talk with the Minister of Economics. And he has a lot of legal people in his ministry. That's done everything to do this law only for companies with more than 3,000 employees. He has done a lot to make it as weak as possible. And weak means not only that it's weak in the out of the view how strict it is for the single companies. It's also weak because it's confusing for companies. And at the end, the small and middle-sized companies are also affected by this law, because the bigger companies will say, hey, I have to do this law, and you have to give me the guarantee that everything is fine in your global supply chain. And they are not under this law. it's more a private law at the end, not really a law. It's more private rules from companies coming now up. Therefore, it's absolutely right. We can talk about deficits, but I have to see the reality. There was not a majority in this government to get a better law, and I don't see the majority inside a parliament to make a really strong law where everything is covered and everything would be fine with 3 pillars, maybe 4 pillars or more. Yes, but you have to see the problem is inside the bigger party of this coalition, the Christian Democratic Party. There are a good number of parliamentarian members of parliaments who wants to have a strong law because of out of ethical reasons. But there's also a huge group of members of parliament who are looking a little bit more on the business side, not a little bit, they look strict on the business side, and they refuse any strong law. So, and that is the reality in the parliament, and that we have to see also as parts of the initiative, Lieferkettengesetz, that we say, yes, it's a game changer and not a perfect one. And, you know, if this law comes, it's not a reason for any NGO or trade union to make a self-dissolution and to do nothing anymore. I think then the work starts really if these laws come. I have, as a trade unionist, I have to see how to involve members of work councils in these processes, how to bring the potential victims of labor law violations along the global supply chains in this changed game of this new law. And that therefore, you know, it's a game changer because it's for the companies really the first time they have to take the human rights into the risk management. They have done it never before. Some companies have done it already, but not the majority of the companies. And I think that is also a game changer, also for all the people who are looking for human rights.
I also wanted to respond to Professor Kieninger. I totally agree that the lack of civil remedy in the statute is a big shortcoming. Access to justice is one of the most fundamental principles of our legal order. And anyone in the world who is harmed by a German person, be it a company or a natural, should have access to judicial remedy. And we have courts in Germany that are capable of judging these cases. I think that the fears of the business association are exaggerated. Something like a flood of lawsuits is not going to happen in Germany, not like in the United States, because there's nothing like penal damages or class actions in our legal system. So really very low incentives of going to court, especially considering the burden of proof and all the difficulties in bringing an international lawsuit before German courts. Even if, as you say, via Section 823, paragraph 2, there will be a claim to economic loss, that will be the actual economic loss and not millions of punitive damages. An act would even have to make it explicitly clear that immaterial damages also covered the suffering of a person. The act would have to make that explicitly clear for that to be claimed as well. So if we introduced a civil action, this would not be the end for the German business community, and it is definitely a shortcoming. However, we must acknowledge that the agency that is responsible for enforcing this act and that will issue fines will also consider how a company behaved after a risk has materialized. If the company has made good effort to mitigate the damage, to undo the damage, pay some kind of compensation to those injured, then the fine will in effect be smaller. The Act does make that clear. So in this way, indirectly, victims will have some kind of, will hopefully find some kind of remedy. And again, this Act will be evaluated in 5 years after it enters into force. The effectiveness will be evaluated, and then I think it should be quite possible to add a civil claim to the statute to complete it.
So for now, I would just like to thank you very much. It's been a very stimulating debate. And yeah, Miriam, Eva-Maria, Frank, Robert, thank you very much for your inputs, for making time for this, and for making the discussion so detailed and lively. It will be very interesting to monitor what happens next in this area, not only in Germany, but also in the EU, of course. So yes, stay tuned, I would say. And on behalf of the Max Planck Institute for Comparative Public Law and International Law, I would like to thank you all very much for attending this webinar and participating in the discussion. And I wish you a great rest of your day.
It was a pleasure. Goodbye.
Thank you.